to the Society for the invitation to speak about contracts, letters of engagement. In our previous session, we had talked about the legal requirements of an enforceable contract, and we'd started to talk about what are the practical requirements of a contract for surveying services, and we talked about the party and project identification, and we were talking about the price of services, with the two main fee structures for surveying services being the lump sum and the hourly amount. We talked about the difference between and where it's advantageous for the surveyor to use the lump sum versus the hourly rate. And in certain cases, the lump sum is going to be the biggest profit for the surveyor, and other cases, such as litigation, where the hourly rate is clearly the better fee structure. We mentioned listed there is a percentage of costs. It's very seldom employed in surveying. I am unaware of any situation where that might have been used. I'm sure it has been. Percentage of costs is very common and is the usual fee structure for realtors and architects. Realtors getting a certain percentage of the price of the property that was sold. Architects get a certain percentage of the construction costs, and therefore they try to make in my opinion, the construction as difficult as possible, putting in lots of curves and so on, and that ups the construction cost, which ups their fee. That next thing on the list, basic, supplemental, and surcharges, we're going to talk more about that throughout this session, because those are important things to consider when looking at a surveying service contract. The basic fee is, of course, either the hourly rate or the fixed fee, but in some cases you might want to use supplemental or surcharges, supplemental fees and surcharges. For example, supplemental fee is if you had to travel a long distance for that project, the surveyor might want to put a supplemental fee for travel time. Surcharges, if they had to do it, let's say, on a fast track, because you're paying maybe your employees overtime or putting them up in hotels and so on. So there would be surcharges in addition to the basic fees that the surveyor might charge the client. And I think you should always consider that. Do I want to have some supplemental and surcharges? And by the way, they don't always have to be additional fees. You might actually give, when you're thinking about writing your contract, a deduction if the client is flexible. Let's say they'll be flexible with when the project has to be completed or things such as that nature. All right, so that's basic, supplemental, and surcharges, and you should always have a little note there. Should I think about basic, supplemental, or surcharges? The basics, of course, you've already considered, but supplemental and surcharges. Always you should have some kind of time. When does that project have to be completed, or when does that project have to be started? Is there a certain schedule you have to adhere to? Maybe there's weather or building or time limitations that have to be met by that client. And then there's always weather that's thrown in there. So that's another important part of the contract. Retainer, we're going to talk about in a little bit. And you might even cross retainer out in your notes and on that put advance payment. What is the advance payment? Should I ask for an advance payment? What are the advantages and so on? We'll talk about that later. Project scope. What's being done? Most attorneys, and certainly the vast majority of landowners, don't know the difference between, let's say, a typical retracement survey and an Alta NSPS land title survey. Sure, there's a great deal of overlap, but I think we'd all agree as surveyors there's a completely different fee that would be associated with one versus the other one. Does that project scope include identification of wetlands or the 100-year floodplain elevation or line? Do I include building setbacks and zoning information? I once went to a bar meeting and gave a presentation about surveying services. And at the bar meeting, I should say it was to the what I'd call the real estate bar. There's litigation bar, there's real estate bar, there's commercial, there's the family law bar. I mean, they break the bar down in these various areas of practice, just like surveying tends to do, although as surveyors, we tend to think we could, do everything. But surely as surveyors, there's those that are using the drones now, and then there's those that do mostly construction or permitting type of surveying services, and then there's the boundary surveying services. A lot of firms do them all. Some are very specialized. But anyway, I was given a presentation to what I'd call the real estate bar, which I thought would be pretty knowledgeable about what the surveyor provides. And I talked about a retracement survey and what the client can expect to receive on a retracement survey. And I was, along with the other surveyors in the room, by the way, was shocked by what the bar thought that we were providing them. For example, I had several members of the real estate bar that presumed because we didn't show wetlands on a retracement survey that, of course, wetlands didn't exist. They thought that was part of the scope of services. That if there's wetlands there, we're going to delineate them. If the 100-year floodplain affected the property, we would have delineated that on a boundary retracement survey. And so sometimes when you lay out the scope of the project in your contract, it's not only good enough to say what you will do for the client, it's sometimes wise to say what you won't be doing for the client. So keep that in mind. And if we get time, we're going to talk about some of the scope aspects that a property lawyer and a lot of clients think that we as surveyors are providing for that client when we agree to survey their boundaries or survey their property. The fourth item there is the standards. Obviously, if you're working on a government contract, they're usually pretty good about putting standards, not necessarily that the standards are good, but they are pretty good about stating standards that they expect the surveying services to comply with. Not that the standards are good, clear standards, but they provided it. For that client, that's the landowner, you're surveying their boundaries, laying out the road location, things like that. It's the surveyor that generally says, this is the standards I conform with. Obviously, in many states, including Illinois, there's mandated minimum standards that the surveyor has to comply with. And I think it's appropriate to state those standards and where they can be found. I would recommend that if there's a website where those standards can be found, to just simply put that in the contract that, surveying services will comply with standards found at and the website. Just put it there so there's no confusing or disagreement about what the surveyor is going to provide the client. I mean, listen, I've been surveying for 50 years, and I've had clients that look at that pin that I put in the ground for a corner with a cap on it and say, is that it for a corner marker? Yes. Well, I was thinking you'd put in something like marble with a little X on the top or something. Oh, yeah, sure. Would you like your coat of arms? Wow, that would be great. No, right? This is what you get, is a pin with my cap on it. It's not concrete. Now, if we're talking about a subdivision where this subdivision requirements for that municipality require concrete monuments, sure, then the client can expect to get them. But, when the client, and I've had a few that say, gee, marble monument, that's when we go back to the supplemental and surcharges and say, sure, I can get you a marble monument there with your family coat of arms on it if you'd like, but it's going to be extra money. Right. But anyway, talking about project standards, we know as surveyors what standards we need to meet. That client doesn't. And I talked about the client that expected more from the standards. There's also the clients that don't realize that we have to comply with certain standards, right? That's the one that says, I'd just like you to survey my one boundary. I just want the one boundary surveyed. And you don't have to mark the boundary. Just give me a rough idea where it is so I can cut some timber or put up out my garden or something like that. It's like, no, we can't do that. 10% boundary survey, right? To find out one boundary, we have to survey all your boundaries, kind of deal. So sometimes you have to go the other way with the client that would like less, and we say, no, we have to give you more because of mandatory standards. And then there are time restrictions that should often be mentioned in that contract, not only for performance, but payment, right? The client, I'm always amazed that clients expect you to drop everything, go out and do their project within 48 hours, and then go on a 3-month pay, think that a 3-month payment plan is just fine, right? And so sometimes you have to let them know in very specific language when payment is due, either partial payments or final payments due. Let's go down and just look at a simple written contract. Again, you don't have to have a written contract, but some of the things we've talked about as far as the practical requirements of contract, we've identified the parties, right? Here, the firm, the landowner, client, we've identified the property location, the type of survey, and its purpose. Many of us, as surveyors, have had the client tell us what they'd like, and then they tell us the purpose for what they're going to use the survey for, and it's not what they've asked for. It's not going to meet that requirement. And so it's always good to not only say the type of survey they get, but also state the purpose for the surveying services they're getting, because sometimes they want to go way beyond and use that surveying services we provided way beyond what it should be used for. The standards, if you've got them, put them down. If there's a website, like I say, stick that down. Fee for services, lump sum fee in this case. We've got a time period here when payment is due. Make it clear. Remember, though, I've recommended that if you're going to have a lump sum, somewhere you probably also want to include an hourly rate, starting date, completion date, and then we talked about retainers, and so I'll jump onto that now. We've got this effective date of this contract. I just want to mention this. I see a lot of surveyors that have prepared contracts that the signature block is not optimum for them. I understand that. Having taught at the University of Maine in engineering programs, and I've also taught at Florida and Florida Atlantic, a lot of graduates that were putting out with an engineering degree and a surveying degree had very little business law. We expect them when we call them up in 10 years and say, what are you doing? And we'd expect them to say, oh, I'm in charge of surveying operations, or I own my own firm, or I start a business, or I'm vice president. I mean, we expect them to be up in management. We've given them no knowledge on management. We've taught them how to do least squares adjustment. We've taught them how to, operate AutoCAD. We've told them and talked to them all about these technical aspects, yet they're going to spend most of their life. And we expect them to spend most of their professional life in the management of surveying businesses. And so often we miss points like this, and I'm going to talk about, but in this contract, notice that it's a corporation that's doing the contract for surveying services. So when you sign, first thing you do is sign with the corporate name. You do not just sign your name. If you're an employee and you're working for somebody and the bosses trust you enough, says, here, go out and write a contract and get business for them, you don't just sign your name. You type in your employer's name in that signature block. You must type in that. If you're going to bind the employer, corporation, sole proprietor, whoever you're binding, their name gets typed in on that signature. Notice that, by their agent. That's where you sign your name. You don't just sign Jamie Grayson. I don't care what the letterhead says. I don't care. It's who signs the contract that's going to be bound by the contract. So make sure you type in your employer's name or write it in. All right, let's talk about retainers. Or an advance payment, as I said. And actually, the advance payment is more proper than the word retainer. They're often interchanged, and I've done it in this presentation. But in fact, an advance payment is more proper for what I'm going to be talking about. Why use an advance payment? You don't need it. I'm not going to tell you, those of you listening to me, oh, you must have an advance payment. No, this is a business decision. Just like how much you charge the client is a business decision, whether you use an advance payment is a business decision. I use it for most of my contracts. And so when we come and the society has these presentations, we often come with years of experience, a great deal of knowledge, and so most of the things that we hear, we say, I know that already. Some of you have been surveying longer than I have. You've been surveying more than 50 years. That's a long time to survey. I hate even thinking about that, but you've been surveying more than 50 years. A lot of what I've said, you said, I've been there, done that. But sometimes you can always pick up something, and some of you have never thought about advance payments. So what's the advantage of advance payments? I say the litmus test as the first advantage. What do I mean by litmus test? Well, litmus test is when you've told the client that the surveying services are going to be $10,000. And then you say you're going to require a $1,000 advance payment. And they hem and they haw, and they say, wow, that's a lot of money. Let me see what I can do. Aren't alarm bells going off in your head? Aren't you sitting there saying to yourself, wait a minute. If this client is having trouble coming up or balking at paying me $1,000, what's it going to be like when I require the other $9,000? Do I really want to work for this person? What you want to see is when you ask that client for a $1,000 advance payment, they say, do you want that in cash or a check? That's the kind of response you'd like to hear. Right? Or at the very least, I'll have it in the mail tomorrow. See, that's a litmus test. It sort of tells you what it's going to be like getting money from the client later. Before, you'd like to know what the temperament of that client is about paying you before you start going into debt to that client. And when I say debt, for those of you that aren't running a surveying business, keep in mind that you loan money to a client on most surveying services. What do I mean by when I say you loan money to the client? It means that you've agreed to do surveying services, you send out the field crew, you're paying them their paychecks, you're putting miles on your vehicle, gas in your vehicle, spending time, and so on. And at the end of the payday, you've paid your employees for the time they've spent. You've spent time on that client's project, and you haven't gotten any money. You've lent the client some money, interest-free money. And it really upsets me and many of you listening to me that when you've lent the client money interest-free, they don't want to pay you. Well, you'd like to get rid of those clients before you start working for them. So the litmus test tells you if there's going to be problems. Right? If they tell you they're going to send the money the next day, and 3 weeks later you still haven't gotten the money, and you've had to remind them 2 more times to send the money, that's a time when you say, you know what, I'm sorry, this contract's not going to work. And some of you listening to me can whisper to that young surveyor next to you and say, yeah, I've been there. I've seen that client. Or some of you would say, yeah, I wish I'd have used an advance payment, because let me tell you about this SOB and how they stiffed me. All right, so that's one reason to use an advance payment. And an advance payment like that is just enough money that most people that are trying to stiff you are going to blink. If somebody's trying to stiff you, get some surveying services for free, you get asked for a big enough advance payment so that they start trying to stiff you right at the beginning, and you can pick up on that fact. All right, the second reason for an advance payment is to keep under small claims court. In some states, it's known as magistrate's court. Almost every state has a court where you can go into and collect money under a certain amount. Usually the amount set, I've seen as low as $1,000 and as high as $7,000. I do not know what Illinois' level is. Somebody knows, that would be a good thing to make a comment at the end of this session. Say, by the way, Illinois' cap for getting into small claims court is X dollars. Now, periodically, this amount's raised due to inflation and so on. But that's an important thing to know. Let's presume, for the sake of explanation, that the small claims cap, the amount you have to be or under in order to use small claims court, which is a very, if you've never been in small claims court, think of Judge Judy or Judge Wapner's court. It's exactly what that is. You don't need attorneys. You're just standing there and the judge is kind of being mean to both parties. And shut up. Did I ask you? It's your turn to talk. What do you say? You know, that kind of just hard judicial judging. And it's kind of scary. Been in small claims court a couple times, and it's just not fun. I wouldn't say, boy, oh boy, I get to go to small claims court, but it's fast. You aren't waiting months and months to get into small claims court. It's production line justice, fast, quick, and dirty. And so a lot of surveying fee disputes end up in small claims court. And you want them to get there. You'd like to be able to go into small claims court and avoid hiring a lawyer, because if you hire a lawyer, what you get sometimes, you end up having to give to the lawyer. It's a no-win situation. So you want to try to avoid hiring a lawyer. So small claims courts, where do you go? And let's say that the cap on small claims court's $5,000, but your surveying contract is $7,000. Well, what you would do is ask for a $2,000 advance payment. By getting the $2,000, what the client owes you on the contract is within the limits of small claims court. So if they stiff you, you can go into small claims court. If you hadn't have asked for an advance payment of $2,000, what would happen is you'd be over the amount of small claims court, and you'd be left either hiring a lawyer, going to a regular court and blowing easily $7,000 just on legal fees, or you'd have to kind of give up on $2,000 and just sue for $5,000 in small claims court. By asking for the advance payment, you put the amount owed within small claims court, and you can go ahead in small claims court and get it. All right, number 3, proof of contract receipt. What do I mean by that? Let me give you an example. I do this a lot. We've had a phone conversation with the client. We've agreed on all the contract terms we've talked about. And I've told the client on a phone, I said, I'll require a $500 advance payment. So the client heard $500. Then in my letter of engagement or letter of agreement, where I restate the terms of the phone conversation, I don't restate $500. I restate an advance payment of $450. I purposely state that incorrectly in an amount that's under $500 or under the amount I asked for on the phone. And then I wait and see the amount of the check I get. If I get a check for $500 after I've sent them the letter of agreement, or also known as the letter of engagement, I realize they probably haven't read the letter of engagement. So I'll call them up and ask them if they got the letter of engagement and, if they had a chance to read it and so on. I don't make a big deal about the difference. I just check it. On the other hand, if I get a check for $450, I now know that they've got the letter of engagement, the written codification of the contract, and they've read it. You see how I use that little ploy to be able to prove that they've got the letter, prove to me that they've got the letter, they've read it. All right, so that's proof of the contract codification, receipt of that. Now there's a fourth reason that I don't have listed in your handouts, and we've sort of covered that fourth reason when we were talking about the litmus test. But keep in mind that on so many of our service contracts, we're loaning the client money. We're giving the client our time, our employees' time, some of our resources, gas, and so on, that the client will then pay us for later. But you can use an advance payment to sort of fund the client's project going ahead. So if I realize that I'm going to have several hours of time and employees' time on that client's project before I can bill the client and recover the money I've loaned the client, why not get an advance payment and then use that advance payment money to fund the client's project? So the client is funding their own project. That would be a fourth reason to ask for an advance payment. Now, I have talked to you about contracts, what should be in them, what's legally required, and certain extra things, because a retainer advance payment's not legally required, but it's helpful for the reasons I've said. I have surveyed long enough to realize, for me to say to you that are listening to me, oh, you should always have a written contract. Sure, that's great advice, but it's not practical advice. A lot of people have pause before they sign a written contract. And so in some cases, especially small lot surveys, it's almost unrealistic to ask for that lot owner to sign a contract before you do any surveying work. Listen, I'm going to tell you, if you are one of those that say, listen, Knut, I always require a written contract, I'm saying, great. That's wise of you. That's smart. But it's just not often done in our practice, especially for, small services. So what I will tell you is that you should always have written evidence of the contract or written codification of the contract. So what do I mean by that? I mean, when you on that phone and you're talking to that landowner agreeing to provide some surveying services, and you probably jotted or you got your computer open and you're typing or writing down the main elements, the amount of fee and so on, what they want, when they need it by, the minimum requirements that I went through for the contract. You sort of covered that. There's been agreement. You hang up, the Client hangs up. You both realize you've got a contract. You're going to do those surveying services. What you should do is now send an email, send a letter. I don't care. Send a Twitter to that client where you state the terms of the contract. The contract will always be that phone conversation. That's the contract. You're in a contract now when you hang up the phone. But by codifying that contract in a letter of engagement or a letter of agreement, what you've done is you put the verbal terms that you've agreed upon in writing. So if there's ever any dispute, you can refer to that document. Now, some states require that the surveying services be evidenced in writing. Maine's one of those. You don't have to have a written contract. What you have to do is have evidence of the written evidence of the terms of the agreement. So you can just send the client a letter of engagement. Let me just state this for the record. If I told you there was one group of people I just cannot get to sign a contract, they just will not do it. The most frustrating group I've ever dealt with as far as getting them to actually put a signature to a document stating this is what they want. And this is what they've agreed. And I said to you, okay, think, if you're listening to me, what group would that be? Think about it. What group? Some of you think, oh, it's got to be architects. Oh, it's got to be engineers. Oh, it's got to be other surveyors. No. You know what group it is? It's attorneys. I hear every excuse available. They just aren't going to do it. I'm just telling you now, if you get an attorney to actually sign a written, good luck. You are better than me. I think in 50 years of surveying practice, one time have I gotten an attorney to actually sign an agreement saying, yes, this is what you'll do. And yes, this is what I'll pay you. I got to run this by my partners. Oh, I got to talk to the client. And then they come back with little changes. You'll be there forever before you start on the contract if you're waiting for an attorney to sign. Use a letter of engagement. So what I've got in front of you is a letter of engagement. Right? So let's go look at this letter of engagement and say, okay, a lot of this you can have on your computer ready to go up and fill in the blanks and have that out as an email attachment or whatever. Just get it to the client in writing. That's all I'm asking. So you've got the client's address, you've got the salutation, and look at that first sentence. Thank you for contacting Smith and Hamlin Surveying Engineers Professional Association to perform your retracement survey. When they get this letter, they don't think this letter is written evidence of a contract. That's not what they think when they read it. What do they think? They think this is a thank you letter. They think this is PR. They feel good about it. It's like, isn't this firm nice? They're thanking me for the business. They don't realize that this is a potentially legal document that's going to be used to evidence the agreement if it ever comes to a dispute. So the next sentence, according to the information I've copied from our phone conversation, that's the contract. The phone conversation is the contract. This is merely a counting of the terms of the contract. So you state where the property is going to be surveyed. Notice that the RID contract we discussed earlier, it's sort of following that now. We got to talk about where the property's at, what the fee was, and so on, the standards are, and so that you'll see these in sentences, right? Where the standards are, the price for the surveying services, when the survey is going to begin, if there's a retainer, when is payment due, what's the time period for payment, all right? You stated all that. Now, there's a question that often comes up at this point that some of you might be asking as you listen to me. Knut, what happens if I want to put something extra in? Like I didn't say to him, we agreed on a fee of $8,000, but I didn't necessarily say on the phone when the fee is due and payable. Can I put that in the letter of engagement? And my answer is yes, as long as it's reasonable. For example, on the phone conversation, if you'd have said, and the fee is due and payable upon presentation of the plans, then that's when it's due. You could go ahead and put those terms in, but let's say you didn't discuss that. Then you have to ask yourself, what's reasonable? Is it reasonable to expect that the fee is going to be due and payable upon presentation of the plans? If not, then you can't include it. But certainly it's reasonable to think that a fee is due and payable within 30 days. That's a reasonable time. So state what's reasonable. You can always include what's reasonable, even though you didn't discuss it. Because the law is going to put, that's what the law, if you ever litigated this, the judge would say, well, what's reasonable? If you didn't discuss it and didn't come to an agreement, then what's reasonable? And so go ahead and put it in. Now, this next paragraph, I think, is always important in a letter of engagement. If we, the firm, have misunderstood or misstated any of the terms of our agreement, which remembers that phone conversation, do not hesitate to contact us in the next few days so they can be resolved. You want them to contact you before the end of the project where they all of a sudden say, you know what, I don't think $8,000 was what we agreed upon. No, you don't want at the end of the project for them to say that. If they misunderstood anything, you want to know about it before you start the work rather than at the end. And again, if you're listening to me and you surveyed for 50 years, you have lots of examples of where you're pretty sure you told the client this, and they're pretty sure you told them something else. And I suspect most of you went ahead and said, oh boy, okay, I'm not going to have a fight here. And you've gone ahead and acceded to the client's understanding. And you've been upset about it. Shoot, I'm married and I have that problem. Well, I thought I told my wife something and she thought she heard something else different. And this is somebody that loves me, that knows me. And yet we're not communicating. And the same's true. She'll later say, but I told you. And I say, I don't remember you telling me that. Huh? Those of you that are married that are listening to me, you could have lots of examples of this, can't you? Well, this is no different than what we have with our clients. We often say something to them, or we thought we said something to them, and they didn't hear, or they heard something entirely different. So put it in writing. You can explain more in writing, right? If you see you can make this letter of engagement into a form quite easily. You put a bunch of blank spaces. The price for our services will be blank. The survey will begin blank. And you just bring it up and you fill it in, you push the send button and it's off to the client. And then if they don't say anything, that's the best news. If they don't say anything, then obviously you recounted the phone conversation correctly. And this adds to your credibility. If you ever had to litigate it and you're saying, no, we agreed on a fee of $8,000. The client say, no, you agreed on a $7,000 a fee. Without this letter of engagement, it's one person's word against another person, right? But because of this letter of engagement, you're able to go to the judge and say, and Your Honor, I sent this to him right after the phone conversation, and I didn't get anything back. And the judge is going to say, you got it, said $8,000. Why didn't you call him then? Well, I didn't have a chance to read it, Judge. Well, whose fault's that? You see how all of a sudden your credibility is bolstered by this letter of engagement. Now, you can also put some other information in there if you have handouts or something. If you're doing a Alta NSPS land title survey, you can include the latest standards. I'm always amazed how some attorneys are like 2 standards behind, have these older Alta NSPS land title standards, and are not the newest ones. So it's always helpful to put those new standards on there. And, if you have any questions, please call or write and so on. And then remember that signature blank. You type in the name of the employer in there. You don't just type your name in without putting the name of the employer in first. All right, so let me just review. Should you have a contract in writing? Sure. Yeah, I think that's smart. Is it always practical to have a contract in writing? No. In fact, let me say this. It's been my experience, and I've dealt with this several times, even with students, with the employment. They've told that person, the students now, have told the person over the phone, yes, they want to work for them. And then I'll see the student being interviewed by other surveying firms. I'll say, wait a minute, I thought you already accepted the job. Oh, I didn't put it in writing. Or they sent a letter to me and I didn't sign it yet. I said, well, you obviously forgot what I told you during the business law, is that you've already got a contract. Whether you sign it or not doesn't matter. The only time it matters is if the contract specifically says there is no contract unless it's signed. So don't ask for that letter of engagement to be signed, because a lot of clients are going to have second thoughts and say, well, gee, maybe I'll just hold off signing this for a while and think about this some more. You don't want a client doing that. You want to say contracts agreed upon, no signings required. Here's the terms of the contract, enough. All right. So we talked about, yes, you'd like to have a written contract. That would be great, but it's not always practical. But you should always have written evidence of the contract. Now, sure, you can write it down in a little scribbled notes, put it in a file, but no, that doesn't really help you. You've got to send that information to the client and say, is this what we've agreed upon? Or not, don't ask them. You want no reply to be good. So you say, unless I hear from you, this is what we've agreed upon. I used to do that with a little side note here. When I'd be surveying, you come across a gas line easement or a gas line. Let's just use a gas line easement. And they don't have a width. It's one of those blanket easements. I'm not going to go explain blanket easements. So if you don't know what I'm talking about, ask somebody in the room and they'll explain to you. But I have a blanket easement without a width. In the first few years I was in practice, I'd call or write the utility company, say, what's the width? And I never get it. You'd think they'd just say, oh yeah, that a width for that type of gas line is, 50 feet, 100 feet. I don't care what it was. Just tell me so I can put it on the plans and my client won't build within that easement, but they won't tell you. Very frustrating experience. And then I learned about estoppel in law school, and I said, whoa, this is some good stuff. I'm not going to explain estoppel either. You could probably look it up on your phone. But I learned that the way to do it is just tell the gas line company, I will presume you have an easement of 50 feet unless you tell me otherwise. Now they have a duty to tell me at least tell me that the 50 feet's wrong. If they don't tell me within a reasonable time, and I usually tell, if you don't let me know within 2 weeks, I will presume the easement is 50 feet wide. Now they have a duty to tell me. If they don't do it, I had every right to rely on that. I gave them a reasonable width, and I gave them a reasonable time to respond, and they had a duty to tell me what their width was. And if they didn't, it's at least I'm protected. So always, if you can, don't ask for the client to tell you, just give the client a presumption. And then put a duty on them to respond if the presumption is wrong. That's how estoppel will work in your favor. Now, I also to talk to you about the written difference between a written contract and written evidence of the contract. And a letter of engagement or the letter of agreement is usually written evidence of the contract. The contract itself is that phone call. Can you add stuff to that letter of engagement? Sure. If what you're adding is reasonable and typical and common practice, put it in. If it's not, though, you need to have agreed upon that. And we're almost done with this second session. So let me just state on the third session, we're going to be talking about some of these other terms that you might want to consider. We're going to get into like advanced contracts, some of the other terms you might want to consider using in your contract. Some add-ons to help you get paid, help you get paid more money, or make sure you got paid, or to protect you from liability. So we're going to talk about some of those terms. Some clauses to add to in most cases, a written contract.